Okay. So, now today we will discuss another important forms of IP. Some cases people told that copyright is a real form of intellectual property where the intellectual contribution uh, is more compared to the other industrial properties. All industrial properties, just like our industrial favors is more, but higher intellectual favors are more. So, just like a copyrights. Copyrights, the word itself indicating the right to copy. Means copyright. If I say separate the two word, just a two phrase copyright. So, right to copy. The right to copy. Now, if you consider who has the right to copy, a copy of what? So, why right is required to be provided, and what right on what, to whom you should give rights, then how the right will be violated, who will be considered violators, what way I try to make some balance with reference to the right of the owners and right of the rest of the people, all those things will come up within the purview, within the scope of this class. Okay. So, now let us say I already told you copyrights is just like say an exclusive right. So, exclusive rights. Okay. So, copyright is an exclusive right just like other form of intellectual property rights. So, if you just like when I tried, let us say let us know how it has emerged. Just like say with reference to let us say copy means ultimately we are thinking about copy in a paper, copy in a CD, copy just like before invention of that electronic media, copy we are considering copy in a paper form. Okay. So, if I go back in say 15th, 16th centuries, so they suggested that before invention of the printing press, people's or creators or author was not bothers about their say about their work to be work and their copies, because understood that the copying was very laborious and tedious job. So, no one was interested to make a copy of a particular poem or particular stories or particular article, because the copy was copying was a difficult task. But when the printing press came, then it was found that lots of say just like every cow has a cup, that philosophy, that okay, every book has a copy by virtue of the printing press. So, then the authors was deprived of their creations. Okay. That lead to that let us say formation of guild, just like some mechanism by copyright association to regulate the piracies and give some sorts of protection to the authors license by means of license. Similarly, by gradually the statute of the first statute with reference to the copyright has emerged. So, it was initially started with the literary work, means let us say with reference to that literary means you understood that whatever I have written here, I can consider this is also a literary work. Okay. So, initially it was started with the literary work, then say same way the piracy was happening in a other domain, just like artistic domain and musical work, architectural work, all those things also came and incorporated in the purview of copyright. Okay. So, you understood why the need of copyrights. Copyrights means to ultimately protect the interest of the creators or authors. So, because when there was an invention of the printing press, then they were that multiple copies of a creator's work have been happening easily. Then the authors were deprived of their rights. So that lead to the formulation or incorporation of statute of Anne. So that was the first legislation with reference to copyright. Subsequently, that different countries have enacted. Subsequently, just like enacted the Copyright Act to protect the creation or creation of the authors, and the domain of copyright have been enlarged from literary work to the musical work to cinematographic films based on the creation. When the creation is more in a particular domain, there is a need of protection. Just like when artistic work was came up huge, then I understood that okay, then also piracy was happening, so then the requirement of protection lies there. Okay, so now so the copyright I am telling there is an exclusive right. When you discussed about the patent, the important difference you will get it here. The right have been designed in a positive way. Patent right have been designed in a negative way, but here right have been designed in a positive way. Means right, exclusive right is coming up in the purview of to reproduce, to issue copies, reproduce understood the reproduction of the original work. To issue copies, you can issue the copies of your work to perform or communicate the work to the public. You can communicate the work to the public. To make translation, you can translate the work. To make an adaptation, I can adopt means okay, just like the adaptation has been defined, conversion of one form of article to another form of article. Sometime you can consider a conversion of two-dimensional thing into two-dimensional things into three-dimensional thing also come up in the form of a two-dimensional thing to three-dimensional thing is come up in the form of adaptation. So similarly, sometimes people is told that conversion of dramatic work to cinematographic work may be come up in the purview of adaptation. Okay, so what are the rights have been provided, including the commercial rental right and also some special right to the authors in the form of moral rights. So exclusive rights and positive right have been casted, and they have been given a bundle of rights. Sometimes they refer as let's say as a broom having a large number of sticks, just like say one sticks to right to reproduce, then right to just like adaptation, so then translation. Those are the say all a bundle, just a broom, all have been enacted together in the purview of copyright. Okay, so each sticks is representing one sorts of rights: adaptation, translation, reproduction, copying, translation, all those things have been represented by within that bundle. Okay, so along with that, say this is another special right have been provided to the authors, that is called moral rights. Moral rights, sometimes we call it a right of integrity, paternity. What do you mean by that? If you draw a drawing as such, I am writing, my writing somehow will not match anyway with another person's writing. So somebody's painting or others painting or way of representing something will not match with another person. So sometimes we call right to paternity or right to integrities. So that is coming up in the purview of moral rights. So these are the a broom, and another special part is coming up within the purview of exclusive rights. Okay, so exclusive right with reference to reproduction, adaptation, translation. Adaptation and translation, you consider just like say you have written a book on German language. If somebody want to make it in the English format, then he has to translate it from German to English. This is a translation. So so that right have been provided to also the authors of a original work. So what are the rights we are getting? So copyright means exclusive right in the form of a bundle of rights, whatever I am explaining in the form of a broom. The rights includes reproduction, issues of copy, performance, work to the communicating the work to the public, make translation, make adaptation, to sell, give on commercial rental. You can give on commercial rental rights also with reference to few cases, few works. Okay, so just like say then as a characteristics of intellectual property rights. So, already I referred the characteristics of intellectual property rights are rights say somehow we give that right to be a limited period right, just like in patent it is exclusive right have been provided for how long 20 years. So, here similarly the exclusive right provided for literary work is in respect of India that if published within the lifetime of author 60 years from the just like exclusive right is for limited period for literary work is published within the lifetime of the authors. I will explain that part 60 years from the beginning of the calendar year next following the year in which authors die. So, life plus 60 years sometime we call it, and for other countries they have generally life plus 70s like this. So, minimum should be life plus 50, and this have been extended considering the Tagore's works in India. So, initially India was also life plus 50. So, now considering the value of the work of Tagore's, the Copyright Act of India amended and the life of the literary work have been extended for life plus 60 years. Okay. So, understood that. Okay. So, what features I will got it? Exclusive right and definitely a limited period, but limited period also some respect what we are getting that even limited period is extending beyond the life of the authors. Okay. So, say you can consider limited period is also on the large chart, means more compared to whatever we have learned with respect to patent or utility model protection. Okay. So, if I now say summarized with reference to the copyright, what do you mean by copyright? Right to copy whatever I layman understanding what mean, but right to copy by is coming up by virtue of a bundle of rights. Means exclusive right to reproduce, make copies, rental rights, selling rights, adaptation, translation rights, and a special right like a moral rights. Okay. And the period of protection is for 60 years. So, we try to get some answer with reference to that why copyright we got an answer to prevent piracy, to give some source of incentive to the authors. What sorts of rights have been provided in the copyrights? I told you copyright have been casted in a positive way, and we have even given exclusive right in the form of say commercial right. Sometimes people refer those commercial right by right to means by virtue of production, reproduction, and along with that special right by virtue of moral rights. Okay. So, you got those thing what rights as such is have been what is the rights in the purview of copyrights, just like a broom, within the broom what are the sticks, you got it, and what special things within the copyrights, you got the idea. Now, so just like a patent protect invention. So, what are the things will come within the domain of copyright? I referred already when I were discussing about the historical development of copyright. So, copyright protects work in the domain of now you got the things just initially started with what literary work, literary work. Okay. It started with literary work, then say artistic work. So, literary work, then artistic work, then let us say musical work, then cinematographic film, then dramatic work also coming up here, dramatic work. Okay. So, I am just not writing. Okay. So, these are the different categories of work will come, just like invention there, product and process. And now, here work in the different categories is coming in the purview of copyright. So, just like I am just reading on my slides, original literary work. So, literary work include computer program, important part here for your technical student. So, within the literary work, what are the things you are getting? Computer program is also coming within the purview of literary work. Then tables, compilation, including databases, or databases also coming within the purview of literary work. Okay. Just like say what do you mean by literary work? If I ask you such like somebody written A, B, C, whether it will consider as literary work, somebody written A, B, will be considered literary work. Whether for to consider something as literary work, whether I require literary merit Okay. Sometime people refer if something provided information, instruction, pleasure. If something, just like I told you, intellectual property per se information. Okay. So literary work that based on say case analysis, I can consider literary work maybe if that work means in the form of literary domain give some sorts of information, or ABC gives some sort of information, pleasure, instruction, then ABC may qualify as a literary work. So similarly AB. It's not like say I don't require to have sufficient literary merits, but should not have mere trivial also, but for that reason they are telling that we should have characteristic like should provide some sorts of information, instruction, pleasure, information, instruction, pleasure, considering that part. Okay. So now for your people within that for your understanding, the computer program is literary work. Table and compilation, if you Excel sheet, you create table and compile some data, then it will be considered as a databases. Data may not be considered as a come within the purview of copyright, but compilation of those data in the form of a databases may come within the purview of copyright. Similarly, arrangement, rearrangement of those data is a compilation. The compilation will be considered a copyright protected work in the purview of literary work. Similarly, musical work. Musical work means music and graphical notation, does not include accompanying word. So this is the definition of musical work as per Indian copyright law, but US copyright law they define musical work includes word, accompanying word. So if I consider song will be considered per se not musical work, because song accompanying the music along with the word. So musical work means song will not come in the form of musical work. Song will be considered as a composite work, means it's considered of musical, consists of musical work, along with that word may come up within the purview of, so a composition of that particular thing will come up within the purview of literary work. But US they consider musical work, I mean song as a musical work. So does not include word, accompanying word. You can consider. Okay. Then dramatic work. Dramatic work just like a for that people act in a drama. Actual acting, if I consider dramatic work and cinematographic film, you understood the difference. Just like here you can create a moving image, here you can actual players act here, but here you create a moving image. Just like video games also can come within the purview of cinematographic film. Then artistic work, the painting, sculptures and others will come in the purview of artistic work. Then sound recording, the important parameters. Just like say somebody is giving a speech, somebody is recording that speech. If that includes the sound and other part, you record that part, may definitely that sound involved in that speech and other part, then the person who is recording will get right with reference to sound recording that part. But now you may consider the that whether it will get separate copyrights or it is a copy of the speech or written by somebody, that the issues. Then architectural work, just like Taj Mahal, Qutub Minars, then Lotus Temple will be considered an architectural work, then architectural work. So now you got the two things, means let us say what copyright is and what will come within the purview of copyrights. Okay. So now one important parameters that whether all works in the literary, artistic, musical work will be eligible to get copyright protection, or we require some sorts of criteria with reference to the each categories of work, including your compilations, databases, or say notation. So the criteria just I referred with reference to the patent, that novelty. So similarly here we have created one criteria. This is very little that we can consider originality. Okay. So the criteria for a work to get copyright protection then is originality. The work should be original works of authorship. Just like if you could read the Indian Copyright Act, that's original works of authorship. Original works of authorship. Now the question lies, if I ask that novelty and originality, how it differs. So novelty means no prior art Novelty means no prior art. Originality means originated from authors. Originals, you understand, no duplicate. So, originated from authors, originated from authors. Okay, original means originated from authors. If I give an example, let us say I have told you to write some answer to some questions, and somehow if all the people wrote the answers, and I found out that all the answers are same, and if you prove that all the answer have originated from each individual without copying to somebody else, then I can consider all are original, not copied, not copied. All are original, not copied. Understood? Originated from the authors, originated from the authors. So, not copied. So, originality means not copied, originated from the authors. Okay. So, originality is the criteria required for copyright. So, if I consider novelty and originality difference, novelty means no prior art. Now, out of those cancers, if some things come up first, then it will be considered compared to the his answers, others answer may not be considered novel, because others one answer is already available in the public domains. Okay. So, but originality means if I so something, if I consider something, say which will be subset or superset, whether all novels are originals or all originals are novel, can you analyze that part? So, novels means already available in the public domains, original means that originated from the authors. So, if something is originated from the authors and available in the public domains, then available in the public domains, then you understand the novelty may be lost, but if originated from the authors, it is original. So, that way you may analyze that difference between the or novelty and originality. Novelty and originality. Novelty means no prior art, originality means originated from authors. But to make this criteria more objectively, different tests have been adopted by different jurisdictions, judiciaries. Just like say, sometime originality is judged by skill, labor, and judgment. Sometime I referred originality is a function of skill, labor, judgment. Okay. What do you mean by skill, labor, judgment? You may read the case of Festos, just like say some on Festo, Fist versus rural telecom industries, Fist versus rural telecom industries regarding the telephone directories. So, one company having the telephone directory, another company asked the telephone directory to them, but that company denied them. Then subsequently that company, second company had gone to the different people, collected the data and created a telephone directory, and some aspects of that those two directories have been found similar. Then to judge whether the one other is original or not, then somehow adopted the skill, labor, judgment type of test. Means they adopted their skill, they adopted their judgment, the skill, they adopted the judgment, they put up their labor, they go to the different people and collected the databases. So, skill, labor, judgment is the requirement for considering originality. So, along with the skill, labor, judgment, another criteria, say feather have been incorporated in US jurisprudence, and some cases in respect of India. Sometimes we call modicum of creativity. Minimum level of creativity should be there in respect of that creation. So, modicum of creativity, minimum level of creativity, along with the not only the skill, labor, judgment, along with that some level of creativity should be there. What do you mean by modicum of creativity? So, understood that okay, you have designed something like this way, somebody may design it let us say different. So, some modicum of creativity involved in respect of second person creation. So, just like say, so skill, labor, judgment is the criteria for say originality. So, sometime incorporated and or creativity, for that reason I am putting out a modicum of creativity, minimum level of creativity, universal pictures case. Okay. So, minimum level of creativity should be involved along with the skill, labor of judgment. Okay. So, that will be decided based on the case to case basis. Again, another part say just like say copyright does not protect idea. Okay. So copyright protection does not available for idea, facts, systems, method of operations. Copyright protection is not available for those sorts of elements: idea, facts, systems, methods of operations. Okay. And another part, that copyright should be so understood, the copyright does not protect idea. So idea we are considering free as air. It does not protect facts, just like a bomb explosion in a particular area, that is a facts. Fact represented in a particular ways, that may be considered to be copyrighted. The systems, method, just like say these are the may come up within the purview of patents. So functionality aspects does not coming, or utility aspect are not coming within the purview of copyright. So another part, say we can refer here, that it should be fixed in a tangible medium. Because why say something idea is how will you evaluate? Last class also I told you how will you measure the idea. If idea, if you fixed in a tangible medium, then you somehow you are tangibilizing that idea. Okay. So for that reason, you may consider that requirement of fixation. Okay. So it has to be fixed in a tangible medium. So for that reason, we referred copyright does not protect idea, but copyright protect expression of idea. So one idea may generate n number of expression, so n number of copyright. So from just like say consider a love stories of a male and female. From that idea you can generate n number of cinematographic film, n number of dramatic work, each will qualify to be copyrightable. What the thing? So let's summarize. So what is copyright? It is an exclusive right for defined categories of work, just like literary work, artistic work, musical work, all sorts of things will come within the purview of copyright. For copyrights, to get copyright criteria means originality, and fixation means should be fixed in a tangible medium. Why tangible medium fixation is required? You understood? Idea is free as air. So ultimately to make the ifs and bounds of the protection, means what are the what is to be protected, at least is required to be tangibilized. Okay. Otherwise how will you consider that? So should be fixed in a tangible medium. Okay. So for that reason we are referring that idea, say copyright does not protect idea. Facts, just like a news item, simply facts, but news item how are you representing? Then just like say each newspaper may the facts part is not coming within the purview of copyright, but the facts they are representing in a different ways, that may come up within the purview of copyright. Similarly, copyright is not provided to the systems, method of operation means utility and aspects. Those are coming within the purview of patents, so they have been excluded from the from copyright part. Okay. So you got some idea just like within a short span of time regarding copyright, because copyright is an essential element for everyday's life. Just like you start reading newspaper in the early morning and you go to bed with listening music. So understood the ambit of copyright. Okay. So you should have knowledge with reference to the copyrights, just like the criteria and of copyright, and how can you create the copyright, all those things. Okay.